Good morning and welcome. It is Sunday, April 26, 2026, and this is Sunday Fun Day from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Thank you all so much for waking up on a Sunday, depending, I guess, on where you live. This might be the middle of the afternoon or even early evening for you, but we're very happy that you've decided to carve out a little time on your Sunday to join us for Sunday Fun Day. Hello to everybody in the chat. Good morning. B Michigan is 100% juiced. I don't know if that's an official juiced reading, but I'll take it anyways. Hello to Lindsay Bay, Miss Annie K, Haley Moo. Miss Annie K says, hey, y'all. Shishi Wolf, Nate Dog Daniels in the house. Caroline Taterville. Sorry. Have book will, I don't know, I missed that last one. I Kennedy, best place to be on a Sunday morning. We agree. Thank you so much for being here. We are so have book will survive from Fort Worth, Texas. Hello to you. Yeah, if you're in the comments, please say hi. Let us know where you're from. Let us know what the weather's like. Let us know how exactly juiced you are this morning. We're so glad to have you. Hello to everybody who's watching on X and on Facebook. Hello to you as well. 110% juice, says McKenna Pate. I'll take it. I'll take it. I'll take that as an official ruling. I don't know if the what the judges say, but I'll take it as an official ruling. We're so glad to have you here. If you are returning, welcome back. If you are here for the first time, so glad to have you. Thank you for joining us. You're really going to enjoy it. But let me introduce myself. My name is Joshua Ritter. I'm a former prosecutor with the LA District Attorney's Office. I was there for over 10 years before I left to go into private practice as a criminal defense attorney. And we started this channel, Courtroom Confidential, with the idea of presenting to you both sides of the courtroom, both sides of the stories, both sides of the issues. And we hope that we do that. And then we started this show every Sunday that we call Sunday Fun Day, appropriately enough, where we take your questions, your voicemails that you have left us throughout the week, and we are now going to answer them live. And there was a lot this week. It was fantastic. Some of them were along the same subject, so I had to kind of pick a few that represented the overall concern that a few of you had. So I wasn't able to get to every single one of them because we'd be here till next Sunday. But if you didn't get picked this time around, please don't be depressed. Please don't be sad. Please don't be dejected. Just leave us a message again, and we will try to answer your question next time. The Crafty RN, 57% juiced. Fail, 38% juice from Kale Chips. She works on this channel. 43. Okay, well, I guess other than myself, everybody is, oh, here we go. Allie Foley, 93% juice. So juice, she made my voice crack. All right. Please stay to the end for announcements. Susan Riley, thank you so much for the super chat. She says she's so damned juice. I think that's an official measurement. So damned, like a buttload. She's so damn juiced. I take that as an official measurement. Stay to the end. We do have announcements, some fun stuff coming up that I want you to know about, and some guests that we have coming up this week that I'm very proud to announce for you. But for right now, take a deep breath. You've made it. It's Sunday. It's the end of the week, the beginning of the next, depending on how you look at it. Hit that like button if you haven't already. Subscribe if you haven't already. Share this with anybody that you feel might enjoy it. But let me thank Bess Nancy for the Courtroom Confidential membership kicking us off this morning. Always love those memberships. All right. Who is our first call?
Hi, Josh. My name is Jean, calling from Baldwinsville, New York. My question is, with AI able to create realistic audio, video, and documents, do you think prosecutors are going to have a harder time proving things beyond a reasonable doubt, especially if the defense can raise the possibility that something was manipulated? And do you think prosecutors are at risk of losing juror confidence in digital evidence? Looking forward to your answer. Thank you.
Jean from Baldwinsville, New York. Let's put you on the map, Jean. Appreciate you calling in this morning and starting us off. I love this question too. I was actually thinking about this myself. AI has become disturbingly good. I get sent, from my friends, like AI videos and AI pictures, but the videos even where they're able to take, living people and put them into ridiculous situations. And it used to be, I feel it was just a few months ago, you could so clearly go, that's fake, that's AI. Now, I feel like the only way that you're telling that it's fake is you're like, well, this is a ridiculous situation that would never happen, so therefore I know it's fake. But if I'm just looking at the appearance of it and the voices of someone, amazing what they can do. And it's usually with people who have a lot of data out there. If it, the president, he's been photographed millions of times. We've heard his voice on tape millions of times. They can recreate the president fairly easily. I imagine with the amount of tape on myself, they could probably do my voice fairly well. It's disturbing, like I said. And I was thinking about this same question, Gene. What about in the context of evidence? What if somebody brings in a video or a photograph or a piece of audio tape? How are we supposed to tell that that is authentic or not? Well, it used to be, and it still exists, that you would have this concept of the best evidence rule, where if it was contended the authenticity of a thing, audio, video, document, that you would have to bring in the actual document itself, the original. Well, what do you do about that when you're dealing with the digital world where things have been recorded many, many times over? I do know that as much as there is a industry of AI, there is also a cottage industry of trying to detect AI. This has become especially problematic in the university culture too. Kids are just having AI write their papers for them. And professors have now tried to figure out clever ways of determining that. I know that one of the things that they'll do is they'll put like some bizarre prompt somewhere in their the prompt that they give to the kids, like write a paper on X, and then somewhere hidden in there, it will be, oh, and by the way, you must use the word slip and slide exactly 5 times throughout the essay. And it's like the AI can pick up on the gist of everything, but might not get that specific prompt. Anyhow, stuff like that. In the courtroom system, though, I imagine you're going to be seeing it more and more. I imagine you're going to be seeing situations where people are contending the authenticity of something. Oh, here we go. Pardon me. I don't know what I did. If I did that map, I don't know if I sneezed the map back onto the screen or not. Sorry about that. But, and now I sneezed it out of my brain. Oh, they're going to have to figure this out because, I think it won't be as big a problem, surprisingly, in the criminal context, because most of the evidence in court is coming from investigators, coming from prosecutors, and they already go through great lengths to make sure of the authenticity of the evidence that they're producing. But what about in the civil context where people are suing each other and it's a little less particular how evidence was gathered? I could see it being a problem. The answer to your question, Gene, is are we living in a world where this is going to become an issue and where jurors might become more and more naturally skeptical? I think absolutely yes. And they're going to have to address it. And I imagine we're going to be seeing regularly on witness lists AI experts just to determine the authenticity of things that are presented in court. Fascinating and disturbing world that we're living in. Thank you so much, Gene from Baldwinsville, New York, for kicking us off. Eroy, thank you for the super chat, says digital metadata should be able to identify the source of the content. I think digital forensics is going to be very, very important as AI grows. I completely agree. And that's kind of what I meant, like digital forensic experts, AI experts. I'm curious, and I don't know enough about this, but I'm curious, like, it's one thing if you could say from the metadata, this is a AI created thing. But what if it's been reproduced more than once? What if it's a recording of a recording type of thing? Can it detect that? I don't know enough about it, but you're right. The person who would is a digital forensics expert. And I imagine those people are, if you're looking for an industry to get into, if you're encouraging your young ones what to study in college, I would say this is probably a good career path. All right, let's keep it rolling here. Great question.
Hi, Josh. This is Tina from Hamilton, Ontario, Canada. First time caller, been watching for a while. My question is on the Nancy Guthrie case. I've always wanted to know, when the video shows him going to the weeds with the light in his mouth and he bends over and he turns the light on, have they tested any of those weeds for DNA? Because I'm sure saliva must have fallen out of his mouth. And if not there, why haven't they taken the brush that's at the door to test for his DNA and that mat? That question's just been bothering me since I started watching this from day one. Great show. Love Courtroom Confidential. And sending love from Canada.
Tina from Hamilton, Ontario, Canada. Sending love. We're sending it right back at you, Tina. Thank you so much for calling in and for being a first-time caller. I love that. Love first-time callers. Thank you so much for all your support and for now participating in the conversation. And this is a great question, too, talking about Nancy Guthrie. From early on, you're very astute and you're very observant, Tina, but you're not alone, because very early on, people did notice that as masked up as this perpetrator was and wearing gloves and all the steps that he took to avoid detection and especially leaving any kind of forensics behind, DNA or fingerprints, he made the mistake of putting that device, that flashlight, in his mouth. Well, how to get it out of his mouth? He's going to have to use his hands, and therefore DNA is going to transfer from the saliva in his mouth to that flashlight to his hands in some even microscopic way. We'd imagine that that might get transferred to somewhere else. The answer is they have not told us what they have tested, but I am sure they have tested everything that you are mentioning. Did they test the bushes? I'm sure they did. DNA is a fairly robust molecule, and it can be picked up on things like, shrubbery, on the doorknob handle, on the device, on the ring device, the surrounding brackets that it was mounted to. The device is gone, but the surrounding brackets inside the home, everywhere. Here's the issues with DNA. If it's there, it's fantastic if you can find it. So there's one thing. Did he leave DNA? I have no doubts that there are trace elements of DNA from this person somewhere on that property. Were they able to find it is the next question, right? Because it's not like blood where they can use those luminol detectors and see where the blood might be. You can't do that with DNA. So you're just trying to swab in areas that you hope to find the DNA. Other problem with that is that you can't do it in as thorough a way as you might with fingerprints. They can dust for fingerprints everywhere. I've been on crime scenes where it seems like the entire room is covered with fingerprint dust. Can't do that with DNA. You have to be more selective because each one of these samples has to be tested. And then when you find it, it has to be a clean enough sample for them to make a profile out of it. So what we do know is that they have at least one mixed profile with male DNA. And I believe they have now an isolated unknown male profile that they're working on putting through that IgG process. I know that the FBI recently, there was a story that came out that they received the hair that was recovered from the home. I don't know if that was that they received it recently or that they had already received it and were now receiving reports that they received it. There was some issue about that, but the FBI has it. They're working on it. There's still leads being worked on in this case. And thank you, Tina, for pointing out some of the things that we all hope they're not missing. Answer is we don't know, but I'm hoping that they are at least as astute as all of us are about the things that this person may have touched. Great question, Tina from Hamilton, Ontario. Thank you so much for asking. All right, let's keep it rolling here. Judd Buchanan, thank you so much for supporting the mods with coffees. Appreciate you. Hippie Mimi has been a member for 10 months, everybody. Happy crewversary to Hippie Mimi. And Alicia K. Mayo, 18 months. Wow. Welcome back at Kathy Mama Bear. Yes, welcome back, Kathy. I hope that you're in the chat. We hope that you're doing well. All right. Let me see.
Hi, Josh. This is Sandy from Egypt. I haven't reached out in a long time. I was traveling, so I just had to send you a question for this Sunday. I hope you and the CC crew are all doing great. Question. So if D4VD is not responsible, if he says she overdosed, and of course Ms. Rigas, is it? In any case, if he says it was an accidental overdose, I had nothing to do with it. But isn't he also responsible? And maybe you've been discussing this and I've missed it. I mean, she was a minor living in his home. Doesn't he have some responsibility to her as the adult in the house? Isn't he supposed to have some duty of care for her? Have I missed this discussion? Because mostly I've heard, well, his defense would be it would be an accident. But it seems to me, forget that when you look at his responsibility for the act itself. What do you think, Josh? Sorry to ramble. Take care.
You did not ramble at all, Sandy. And yes, you all heard that right. Sandy hails from Egypt, putting Egypt on the map. I love it. Thank you so much, Sandy. Good to hear from you. Glad that you're back with us. Hope that you had some safe travels. Talking about the David case. I say David. I've heard D4VD, and I refuse to waste all those syllables. I'm going to just say he was going with David. Early on, we had discussed about whether or not this was a accidental death. And that was, I think, probably what the investigators were struggling with for some time, is trying to determine cause of death. Could this have been accidental? They were waiting on the toxicology report for some period of time, which can take months to get toxicology. If you watched our episode that we did with Joseph Scott Morgan, he talks about how it is not, and I'm not trying to get overly graphic here, but it is not an easy process to extract material from a body in a state of advanced decomposition in order to even conduct a test like toxicology. There's the episode. We will put the link up for you as well. And so he talks about that this isn't blood. You're not dealing with blood when somebody's in this advanced state of decomposition. You're talking about taking material from that person's liver, and then you have to put it through an entire centrifuge process to liquefy it and then test it. You know, we're talking about advanced laboratory forensic work that can take a matter of months. When they got those results back, the results came back for presumptive positives on things like MDMA and benzodiazepines, which are things like Xanax, but not for something like fentanyl, something that might cause an accidental overdose. And I thought, well, that was probably a relief to investigators, knowing that this isn't going to be some case where there's still a question as to how she died. They have now, since their findings, and their findings have been out for some time, they haven't been released to the public. Their findings are that she was stabbed to death, essentially. So as far as arguments that he may make about an accidental death, I don't know if those are as strong as they used to be before this medical examiner's report was released. But to your question, Sandy, does he owe some sort of responsibility to her being a minor, essentially in his care? And the idea is yes, but you're talking much more of a civil context when you're talking about things like duty of care. We're concerned right now with the criminal context of it. And he has been charged with an assault on a minor. He's been charged with murder, obviously first-degree murder. He's been charged with mutilation of her body. There's special circumstances attached to the first-degree murder. So they've thrown the figurative book at him. If he's convicted of the murder and one of the special circumstances alone, he's going to prison for the rest of his life without parole, bare minimum. So this is as serious a case as it can get. It's going to be interesting to see what exactly the defense theory is on this. I know that they've been very vocal and very confident in saying he did not cause her death. Well, somebody with a sharp object caused her death and then chopped up her body and then put it in the trunk of his car. The prosecution seems to be fairly certain it's him. We'll see. And we're probably going to find out sooner than we all had even anticipated, because it looks like, as things stand right now, the prelim may begin next week. I am astonished by that. My prediction was they're going to ask for more time. I'm even going to double down on my prediction. They're back in court on Wednesday. I'm going to double down. You heard it here first. Are we allowed to like turn off the recording of a live stream while I say something dumb? They're saying no. I predict on Wednesday, the defense will come in and say they want more time. We'll be talking about it Wednesday evening to see how smart or dumb I am. I'm astonished on a special cert case that they are steamrolling through this as quickly as they are. Okay. Playing a healthy game of chicken with another person's life there. Jen Lavalate. I love that. And then there's the latte for proof. Says, can Celeste Reeves' parents be held accountable for her death as well? They let her run loose. This is a question that is a lot of people have asked. It's a very sensitive kind of issue. You know, my heart breaks for what this family is going through. They've lost their beautiful daughter. It sounds like she was a very troubled young person. This was not the first time she ran away. She had run away multiple times. They had reported it to authorities more than once. She had always come home. And I think that's probably what they thought was happening here, that Celeste ran away again. Oh, did you tell the police? Yeah, we told the police, but they won't do anything. And nobody really took it all that seriously. And then all of a sudden they find her dead body. And I can't imagine what they're going through. Can they be held accountable? I don't think so. I really hesitate to kind of start going down that path. I fully understand what you're saying, Jen, as far as should they, could they, were they in a position to have done more? I get it. If one of my daughters goes missing, I don't think I would appear to be as I don't know if unconcerned is the right word, as I think I would be far more thoroughly proactive and panicked while she was gone. And a lot of people have mentioned this. Let's take care of who the real criminal is here first, in my view. If this man is responsible for her death, let's concentrate our efforts on that for right now. All right. Celeste. Okay, I missed that one. Kim Tannehill, thank you so much for gifting the membership. Appreciate you, Kim. Very, very kind of you. And Eroy, thank you so much for supporting the mods with coffees, keeping those mods wide awake on this morning. All right. That was Sandy in Egypt, by the way. Egypt. You heard that correct. Egypt. Now a new stop on the Courtroom Confidential 2027 World Tour. All right, get your passport up to date, Kaylin. All right, where are we at here? Oh, Ritter. What did I do? Oh, I see. Okay, hold on. Here we go. I found it. Don't worry.
Hi, Josh. This is Taiwanda from Huntsville, Alabama. I am currently watching your Sunday Live from this week, the 19th, and you were discussing the slippery slope of parents being charged for their children's crimes. And you asked the question, if it stops with guns. Well, there was a case in Florida a couple of months ago. Well, the trial was a couple of months ago of Richard Seymour Ferguson, where his teenage son took the car. hit a grandmother plus her 3 grandchildren and killed them all. And the father was sentenced to, I believe, 35 years, um, 37 years eh, uh, out of Florida. And he's going to spend the rest of his l- l- life in jail because he was 69 years old. He got 37 years. Okay, thank you. Just send in a message to let you know that it's gone past just guns. It's also cars as well. Thank you. Bye.
Taiwanda, thank you so much for calling in from Huntsville, Alabama. Let's put you on the map there. Love this question. Yes, this is exactly what I'm talking about, Taiwanda. We had been talking, I guess it was last week. She was saying that she was watching the Sunday Funday from last week when she was asking this question, but we have talked about it more than once. Cases like Ethan Crumbley out of Michigan, Colt Gray out of Georgia. These are cases where the law has long since dealt with the idea of parents that were negligent, parents that could have done more, didn't do more. Their kid does something awful, and we hold those parents responsible for the negligent oversight of their children. But what's happening now, and these are really truly groundbreaking cases, especially the Ethan Crumbley case, was the first case where parents had been found not guilty, charged and not and convicted, not for their negligent oversight of the child, but for the actual crimes committed by the child. Think about that. Take it out of the context of parent and child. Put it into a different context, okay? Put it into a context where someone has some control or influence over somebody else. Parent-child is the easiest example, but you can think about other examples. And that person, an independent person, goes out and commits a crime, and you're going to hold that supervisory role, the parent, responsible not just because they could have done more and they didn't, but for the actual results. The criminal law is very concerned with the actions taken by a person. We talk about the mens rea and the corpus of a case, the actus reus, the thing that the person did and what they were thinking at the time. And both of those become incredibly tenuated in a situation like this. Colt Gray, same situation. Very troubled young man. Access to weapons. Yes. Horrible parenting. No doubt. But he didn't put the gun in his hand that morning and say, Colt, go do what you need to do. And he's been found responsible for murder, not negligent oversight, not bad parenting, murder. Well, this is another example. Richard Seymour Ferguson that Taiwanda points out of Florida. This was back in September of 2023. He allowed his 15-year-old son, and this was, we talked about, I said this at the time, where are we drawing the line here? Is the line guns? Is that what we're saying? You cannot have a gun in the house without it being properly secured, and if something happens, you're responsible. Well, here's a case that doesn't involve guns. He allowed his 15-year-old son to drive without a license. That is bad. That is bad. But the law, the prosecutors in Florida are not holding him responsible for that. They're holding him responsible for what resulted, because his 15-year-old son went out driving like a maniac. He blew through a stop sign, going 80 miles per hour, runs into a car, kills the grandmother and her 3 grandkids. Trinidad Hernandez, age 50, Miley Cruz, age 11, Marvin Cruz, age 9, and Anna Yari Hernandez, age 1, dead. He just got convicted for their deaths. He got sentenced to 37 years. I know a lot of people are saying good. You let your son drive without a license. But the son is the person who was behind the wheel. The son is the person who decided to go through the stop sign. The son is the person who decided to push on that accelerator till it reached 80. Dad wasn't in the car during any of this. That's where I begin to have a real problem. That's where I begin to talk about things like slippery slopes. It really, I don't know. I don't know the answer to all of this. I don't know where we start to draw the line. I feel like the line is before this, if that makes sense. But great question, Taiwanda. I think it's something we're going to have to figure out, though, because I don't think we can kind of deal in this gray area as much as we are. The criminal law doesn't like gray areas. Great question, though. Great question. All right, let's keep it moving here.
Hey, Josh, it's Jennifer from Lansing, Michigan. I have a question about, well, you can hear my dogs in the background, but I have a question about the Tyler Robinson and the cameras in the courtroom. I watched Andrea Burkhardt's coverage on it, and I'm confused as to, doesn't everybody watch some sort of news, and how is like the nightly news better than the YouTube creators who watch it and give their opinion on it? Isn't that everywhere? Anyways, I appreciate you and your team, and I just want to know your take on the cameras in the courtroom for the Tyler Robinson, and also how Kathy Nestor didn't fight to keep out the cameras from Kouri Richins. So thank you.
Jen from Lansing, Michigan. Let's put you on the map. Jen, you must be reading my mind. I'm so glad you asked this question. This is something that, usually I don't get kind of bothered by defense attorneys bringing up arguments in court. I am a defense attorney. I can completely respect trying to pursue, whatever avenue you feel is appropriate in the zealous advocacy for your client. I'm all about that. This isn't about that at all. This to me is about, it's something bigger. And I feel that the arguments being made are disingenuous. One, you bring out, yes, she just had a high profile case. I didn't hear all this vexation about the cameras in the courtroom in the Kouri Richins case. Maybe it existed. Maybe it got kind of handled earlier on. She was the second attorney brought on. But they're certainly making much ado about it in this case. We have had several hearings on the cameras, what they can show, what he has to be wearing, where they can be pointed, how far away can they be. A lot of concern, way too much time spent in court worrying about these cameras. And then recently, last time they were in court, an entire hearing on whether or not cameras are going to be allowed in the courtroom moving forward. But what they failed to do, in my view, is exactly what you're asking, Jen. They failed to connect the dots. They failed to show a nexus between the cameras and the grievances that they are claiming. They went on this absolute grievance parade where they talked about how unfair the media has been to their client. And they showed clips, and they showed talking heads, and they played video from inside the courtroom of people saying things that they thought was unkind towards their client. And then they even called an expert. This doctor, is it Edelman? I think that's it. Edelman, who was an expert previously in the Brian Kohberger case, to talk about this, how pervasive the media coverage is. And they would play a clip from CBS and ask him, now, What do you think about that? Oh, well, it's really biased and it's really awful and it's really unfair to the defendant in this case. Fine. But what they didn't do, Jennifer, is say how the cameras created that problem. Sounds to me like they've got a problem with the media coverage of this case. Okay. But the media coverage is the editorializing, the commenting on the video. The video isn't saying anything. The video is what happened. You watch a football game and the video is what happened. It's the announcers who are telling you what they think about it. Was that a good pass? Was that a bad pass? Was that a blown play? Was that a strike or was that a ball? But the video is the video. It's objective. It's unbiased. It's as unbiased as anything can be because it's just showing you exactly what people are saying and doing inside of the courtroom. But they're trying to say that if we get rid of the cameras, that will somehow make the media more fair. No, it won't. They're going to cover this anyways. So what do you want? Do you want people who are reporters inside of the courtroom then going outside and telling you what they believe and what they remember taking place inside, and then people reporting on that? We've dealt with that before in other cases, and that wasn't to great effect. I think we can all agree. They have not made the connection, in my view. What they want to do, what they would love to do, you could tell, is shut down the media. But there's this pesky thing called the Constitution getting in their way. I don't understand it. It's a preoccupation with this. We're spending far too much time on it. Part of the blame falls at the feet of the judge. He should shut this all down. But they are so concerned with trying this case in the public forum when they should be far more concerned with trying this case inside the four walls of that courtroom. Who cares what mean things people are saying about your client outside the courtroom? Get down to what they're saying about your client inside the courtroom. And the cameras, I think, are only going to serve to make sure that everything is transparent and objective and unbiased, so that when you have some talking head saying X, Y, and Z, you can go back to the tape and see whether or not talking head is full of it or not. It is far too early on a Sunday for me to be this heated about this, but it's just a disingenuous argument to me. And I feel like the judge is falling for it. And I feel like if the judge does fall for it and doesn't allow cameras, that will be a great injustice in this case. Thank you, Jen, for getting me all heated on a Sunday morning. Eroy, bring me back down to earth, says someone should tell Nestor that some of us were innocently watching a live stream when her client allegedly exposed us all to horrific acts. Yeah. I mean, this is the irony not lost in all of this is this was allegedly an act committed for the pure purpose of getting attention. And now they're saying we don't want attention. Heather Cooper Smith, thank you so much for the super sticker. Appreciate you. And Potter, thank you so much for the super sticker. Says, I am. Yes, you are. I don't know what that's connected to, but you are. You are, Ann. All right. Where are we at here? Calm down, Ritter. Here we go.
Hey, Josh, this is Amanda from Provo, Utah, aka Loves My Dogs. I have a couple questions for you. The first is, what kind of coffee, how do you like your coffee? Because I was going to run you down some because it was freezing here the other day and I didn't know. So, second, so I know Kathy Nestor is the only death penalty qualified attorney in Utah that would take the case. If it's just you and me, and I will tell you how I know that, but not here. Anyway, my question is, are the other attorneys on the case that are not from Utah death penalty attorneys, death penalty qualified attorneys? And why are they able to bring out-of-state attorneys like Novak to the case, to be a part of the case? Anyway, let me know. I'd love it if you brought Tiff to town, and I'll take you guys to dinner. And I love your podcast. Have a great day, and I hope to see you soon. Bye.
Amanda from Provo. Let's put you on the map. Yeah, Provo is where the Tyler Robinson case is being heard. There she is. Loves my dogs. Hey, it's me. I was in Provo for the Tyler Robinson hearing. It was cold. I got some grief about being bundled up in a overcoat and a scarf, but it was like 28 degrees in the morning when I was standing out there freezing off my tail, waiting to talk about the Tyler Robinson case. I like Provo, by the way. Nice little college town. There was a great restaurant that I went to, and I'm forgetting the name. Next time we talk about this, I will remember the name because they deserve a shout out. Really, really good food, just about a block or two away from the courthouse. But to your question about, yes, Kathy Nestor is, so just so you guys understand the dynamics of this, she is not a public defender. He is not paying for his attorney. The state is paying for his attorney. The taxpayer is paying for his attorney. But because he is charged with a capital offense, they can't just assign this to any, I'm not even sure if they have a public defender's office. If they did, they can't just assign it to anybody in the public defender's office. They have to assign it to an attorney who is, quote unquote, death penalty qualified. This is because it's being appointed. If he were paying for his own attorney, he can hire whoever he wants, as long as they've got an active bar card. But if he's being appointed an attorney, the state requires that that attorney on a death penalty case be, quote unquote, death penalty qualified, which Kathy Nestor is, and apparently one of the few people in the state of Utah who does satisfy that qualification. So she's been appointed. She is billing the state for her time. That is on a set schedule. It's not whatever full freight she usually charges clients, but it's on some sort of pre-negotiated set schedule. But she's billing the state for her time, and for the time of the other attorneys involved in this case. I am sure that part of the negotiations included, by the way, I can't do this on my own. I need, a support staff of 2 other attorneys and however other many people, and they're going to bill for their time as well. Those other attorneys, some of them are from out of state. Why am I blanking on this guy's name? Give me the name of the guy who's been talking in court most of the time. He is from out of state. I don't know if he is death penalty qualified, but the answer is he probably doesn't need to be, because Kathy Nestor is, and she is lead counsel. That kind of satisfies the requirements for everybody on her team and satisfies it for any people who might be out of state. Those attorneys are operating under what we would call a pro hoc vice sort of assignment. You don't need to be licensed to practice in that state as long as you are for a temporary period for a specific purpose, operating under the guidance and supervision of an attorney who is licensed in that state. Richard Novak, that's who it is. That's the gentleman on the left there. So yeah, that's how this is all being done, is through Kathy being lead attorney. She's the death penalty qualified one. She's the licensed in Utah one. And that's how they're all able to work on this case. And how do I like my coffee? I like it. I usually like it black, but I prefer it in a Courtroom Confidential mug. All right. Great question, Amanda. Thank you so much. Next time, please come say hi. Ann Potter says, I am going to try this again. Happy Sunday Fun Day to all again. Happy Sunday Fun Day to you, Ann Potter. Thank you so much. Coffee and tea donation for our fabulous mods from Annalie Finch. Appreciate you, Annalie. And KY Granny. Get juice, Josh. You seem punny today. Yeah, I'm in a bit of a punny mood today. All right. Where are we at? Here we go.
Happy Sunday Fun Day. Josh, Courtroom Confidential, Tiffany, mods, and of course the confidential grizzlies in chat, and any newcomers, welcome. This is Court Liquor calling from Spokane, Washington, and I have kind of a generic question. I partially know the answer, but I would like more explanation, if possible. Please, Joshua. So, when it comes to cross-examination, there is a scope they have to stay in, right? So, I'm curious as to why sometimes the judge, when it comes to that side's cross-examination, lets certain things slide that was not in scope, but then allow or not allow other things. So I'm kind of curious as the rules to cross-examination. I know with cross-examination, excuse me, you can ask leading questions, but I also know you have to stay in that scope as well as redirect, right? Am I confused? Can you please explain that a little bit more for us? I would appreciate it. I appreciate everything.
Court Lurker from Spokane, Washington. Let's put you on the map. Thank you so much, representing the Northwest there. Good question. I think what this question illustrates, Court Lurker, is the frustration of being a trial attorney. Yes, there are rules. Sometimes they're followed and sometimes they're not, is kind of the end result of it. A lot of times you can understand how a judge might bend the rules a little bit just to grease the wheels of everything and keep things moving quickly. But sometimes judges don't understand it, or sometimes they're just getting it flat out wrong, or sometimes they don't care. And so, yeah, every trial I've ever done, you're kind of figuring out, you know, it's like an umpire figuring, I don't know why I'm on this baseball kick today, but it's like figuring out the strike zone. What does this judge allow? What doesn't this judge allow? And those are not necessarily always strictly by the rules. I've had judges who are strictly by the rules, and I'll tell you, sometimes that's frustrating as well, because you may have a situation where something is, you know, according to the letter of the rule, shouldn't be allowed. But we all know we're going to get there anyways. And why are we jumping through all these extra hoops to finally end up in the exact same place? And it's because that judge goes, well, that's the rules. So one of those rules is on the scope of cross-examination. Yes, the rule is cross-examination is limited to the scope of direct. Now, most times that is not very clearly defined, right? You're calling a witness. Let's say you're calling up an eyewitness to a armed robbery at a liquor store. You're going to ask that person, you know, what did they do that day? What did they see? Where were they standing? What did they hear? All those types of things. What you're doing, though, is creating the scope of essentially the events of the crime itself, right? You can't say, well, I didn't ask that person what they heard, therefore they're not allowed to ask them on cross-examination what they heard. That's not how specific it gets. So the scope could be an event, a day, what they witnessed at a certain event. And then that opens up everything on cross-examination to ask about that. What it doesn't open up is for them to go, okay, well, didn't you the day before get into an argument with your husband, and therefore you drank a lot that evening, and therefore you're, you know, stuff like that. That's outside the scope, right? And if you want to get into that, you're going to have to either recall that witness or explain to the judge how it's material. Now, there are situations where things might be outside of the scope, but the judge feels like, you know what, this is important and something we're going to get to anyway, so I'm going to allow them to have it. My example might be a good one. If you know that witness, that eyewitness may have been under the influence of alcohol or drugs or hung over from one of those things from the night before, and the prosecution never got into all of that, but you feel it's important for the perception of that witness to those events of that day, the judge probably going to let you get into it. Even though it's quote unquote beyond the scope of direct, it's important and we were going to get there anyways, and the judge might allow it. So yes, you are perceptive and you are right, and you are probably catching many instances where the cross-examination is going beyond the scope and the judge isn't doing anything about it. Part of that might be the prosecution's not objecting to it, but even if the prosecution does object and the judge is allowing it in, it's probably being because he just wants to keep the ball moving. He wants to keep this case moving along, and it's important for the jurors to hear the truth anyways. Same goes for redirect. You're right. On redirect, it's only supposed to be addressing things that were brought up on cross, not opening up a whole new can of worms. But again, welcome to my world where it's just kind of up to the judge at the end of the day. Great question, Court Lurker from Spokane, Washington. Appreciate you. All right. Here we go. Not my fault. Pressing all the buttons.
Hi, Josh. It's Jim from the Marshall Islands again. I have a question about judges. I was watching the Paul Caneiro trial, the guy in New Jersey who killed his brother's wife and his brother's kids and burned his house down. And the judge was super active, like I've never seen a judge. He objected to questions. He stopped a question in the middle of the question and said, how can he know that? And so I was very confused. And so I asked ChatGPT, can judges object? And Chat said, yes, of course they can. They rarely do, but they can. And so my question is, if they can, why don't they more? And isn't it kind of misconduct for them not to when they see something that they should object to and then don't when they have the power to? Why isn't there more? If they're allowed to do that, why don't they do it more? It seems like that's something that they should do. If they see a lawyer not objecting to a question that should be objected to, why isn't it happening all the time? Anyway, it was the only time I've ever seen a judge do that. Love to hear your thoughts on that. Thank you.
Jim. Yes, you heard that correctly. From the Marshall Islands. Don't you love this? Look at this. Well, you can't really tell. It just looks like a dot in the middle of blue. But if we zoom out a little bit there, Jim representing the South Pacific. I am just astounded at where we have put dots all over this map. Pretty incredible. Still, we can't crack the code on South America there. What's going on? Somebody right now knows someone who lives in either Brazil or Argentina, and you need to give them a phone call and say, could you just call in and ask a question from this poor lonely man on YouTube so he stops complaining about it? All right. Jim from the Marshall Islands, wonderful question, talking about the Paul Caneiro case and Judge Mark Lemieux and his kind of overly active behavior. We were just talking about judges. Well, this is an overly active judge and his behavior in court and judges objecting and everything else. And I am not an expert on this case. I did follow it, but not as much as others did. And so I decided to go ahead and phone a friend and bring in an expert.
Jim from the Virgin Islands. You asked an important question about the role of a judge at trial. The judge is supposed to be the impartial arbiter. He's supposed to be patient, dignified, courteous. He's not supposed to suggest a bias one way or the other. It's the lawyer's responsibility to make objections. They understand the facts of their case. They understand their strategy, and we expect the lawyers to do that. The judge is not expected to intervene. When he does, it creates the risk that the jurors are going to see his intervention as suggesting that whatever his view is, that's the view that they should take. That's the danger when the judge intervenes at trial. And that's why judges do not typically do it. It's rare when they do it. Now, in this case, as you observed, the defense lawyer repeatedly asked the same question. She asked questions with facts but that were not in evidence. She would ask a question again after the objection to the question was sustained, and the judge got very impatient with it. But the problem is that impatience might have transferred to the jury, and in fact, the defense made a post-trial motion for a new trial based on the judge's behavior, and it's going to be an appealable issue. That's why judges typically don't. Thanks a lot.
That is Professor Joe Potuto from Prof. Joe Explains. She's got a YouTube channel. There's the link. Please go check it out. She is got some incredible insights and always very easy to understand explanations on these things, as was this answer here. So there you go, Jim. They can do it. Sometimes they do, but they should probably try to avoid doing it because it can create issues sometimes. I have seen where judges will, in my own experience, sustain objections if it's kind of like we've already been there, like with this situation here, asked and answered, or a facts not in evidence, and it's kind of clear to that judge what's going on. But sometimes judges sit on their hands and look to the attorneys to do that, and I appreciate that as well, because I'll be honest with you, going back to this idea about rules, I tend to not object all that much. Why, Ritter? Is it that you don't know the evidence code? No, I know the evidence code. It's because I have found that many times when you are asking for what might be strictly objectionable, an objectionable question or objectionable answer, you usually are not all that happy, the person asking it, with the answer you might get. So especially if it's a witness that I know is, one of my own witnesses, and it's on cross-examination that they're asking the questions, sometimes I'll let them go. What are they going to say to this? What did they step in with this silly question that they asked? Yeah, and the results are pleasantly, surprisingly helpful sometimes. So, you can be this kind of rule. I've seen attorneys who are just on top of every question and objecting to everything. I think the other problem that does is it makes it look like to the jury you're afraid of every single answer. No, I've had some situations where I know the witness is going to blurt out a bunch of inappropriate stuff, so I'll be very on top of my objections. And I've had judges who allow me to handle my witness the way I want to. I've had judges who interject their own objections. I've even had judges ask questions of the witness, and this one really drives you nuts. There was a judge, he retired here in Los Angeles. I really liked him. I'm not going to name his name, but I really liked him. Really pleasant older gentleman to get along with. I had a few trials in front of him, but he would drive me up the wall because whenever I was done questioning a witness, he would go, I got a couple more questions here, counsel. And he would start to ask the questions of the witness. And there's nothing you can do about it. And you'd have to sit there and go, sure, Your Honor, and look like you're happy with this whole thing. And the problem with that is that many times you've got a strategy with how you're handling a witness, right? And you're very careful on how you've allowed that evidence to unfold. And if you start allowing someone who's not the opposing counsel to ask questions, it could mess things up. And I remember he at one point asked some questions of my client, and then he was allowing the defense to get up and cross. And I said, well, Your Honor, don't I get to redirect based upon your questioning? And he kind of laughed and he's like, okay, go ahead. And sure. And I had to kind of clean up some of the stuff that he had done. Anyhow, great question, Jim, from the Marshall Islands. Great answer. Thank you again to Professor Joe Potuto for that answer to it. Yeah, you guys, if you've been watching these trials long enough, realize how different a lot of the personalities can be. Kim Tannehill, thank you so much for gifting the membership. Appreciate you. That's very kind of you. Heather Cooper Smith, thank you so much for the super sticker. You're the best. Court Dog Daniel, if the CSAM artifacts on David's phone came across state or international lines, could they charge him federally? Would there be an advantage to that? The answer to your question is yes. If it came across state lines, yes. I am going to tell you guys, I think this has been overreported. Okay. It was mentioned in court by the prosecutor that they found this type of material on his devices. I have not been told this, but I can almost guarantee you they're not talking about stuff he found on the internet or that he's been trafficking in this type of material. What they're talking about is photographs and video of Celeste as an underage minor. Strictly speaking, that's what it is. That's what I think they're talking about. And I don't think he was trafficking this, or at least they haven't alleged that. Could have just been that it was on his phone. And that, could they have charged him with that? Sure. But they're being smart. You don't charge every little thing you can find. You charge, when you're charging somebody with a death penalty eligible murder, you kind of stick with the big stuff. So that might come out in trial. It certainly is evidence that he was committing another crime that he was charged with, which is assault of her as a minor. But I don't think they're going to get into all of this and refer it over to the feds and everything else. But great question, CDD. Appreciate you, my friend. All right, let's keep it rolling here. Oh, boy. I did it again. I don't understand what's going on here.
Hi, Josh. This is Taylor again from Bluffton, South Carolina. Hi, Courtroom Confidential family. I am calling about the Alec Murdaugh case, and I live very close to where he is being tried and for everyone involved. And I am wondering, how long does the Supreme Court of South Carolina have to approve or deny his appeal for a new trial? And if there is a new trial, would it be the same judge again? I can't remember if he retired or not. Or would it be a new judge? Also, can they bring in all of the same evidence? Would anything have to change? If it's the old judge, would he change? Would he have to re-rule on everything? Just kind of wondering how that works. And that's it. Thanks. Have a great day.
Thank you so much, Taylor from Bluffton, South Carolina. Let's put you on the map. Where is that? Is that the one that's got the circle around it? Could you zoom in? I have never been to South Carolina, and I would love to go, and I'm waiting for an excuse. And maybe something to do with Alec Murdaugh will give me an excuse, and Fox or somebody will send me out there, because I just, in my head, it just, I think I've overly romanticized what it's like down there, but I would love to visit. So in the meantime, this is as close as I'm going to get. Thank you so much, Taylor from Bluffton, South Carolina, asking about the Alec Murdaugh case. Yes, so he has appealed. Part of that appeal is based upon the misconduct, which she's been convicted for, of the courtroom clerk, Becky Hill, in that case. Oral arguments on his appeal were heard back in February of this year. The answer to your question of when will they decide is there's no deadline. They will decide when they decide. I imagine you could get a rough estimate based upon, how long they usually take on these things. I wasn't able to find that information. I will tell you, we're not talking a matter of years. We're talking a matter of weeks. I expect that any day now, what are we, February? We're a couple of months out. I would probably say within the next month or two, we should probably hear where things stand on that. And by the way, prepare yourselves. He might win this. If I had to bet, I would say no. I would say that the Supreme Court will find some clever reason to deny it, but this is not a frivolous argument being made here. You remember, okay, so first of all, let's answer your question as to who it would go back to if he did win. Judge Clifton Newman, very good judge, but he was retiring. This was his last case, presided over the trial. If it goes back for a retrial, Judge Newman has retired. It will sit in front of a new judge, and that new judge will make their own evidentiary hearings about everything. If you get a new trial, you get a new trial on everything. You're not stuck to the same rulings made by the previous judge. But will he get a new trial? Well, you remember he brought these arguments up in front of, back in, when did this take place? Was it that long ago? January of 2024? That's what I have in my notes here, that he was in front of Judge Jean Toll, where they brought in the jurors. I don't think he got a fair shake here. I really don't. And I hate to say that because I believe the man is guilty. But this wasn't about guilt. This was about what took place, the shenanigans between the courtroom clerk, Becky Hill, and these jurors. And all the jurors said, she spoke to them, or several of them said she spoke to them, and she talked about it. And she said things like, watch him, don't get fooled. That's horrific. That is horrific. I don't care if you're a prosecutor or defense attorney, you should be tremendously offended by that. The attorneys are under such strict instructions to not interact with the jury that I've had judges tell jurors, by the way, don't even say good morning to the lawyers. If you happen to get on the same elevator as a lawyer, they're going to ignore you. And we do. I have had a situation where a juror asked me where the restroom was. And I said, oh, it's down the hallway there. Before I realized that was a juror in my own trial, and had to bring it up in front of the judge, say, Your Honor, I interacted with this person. They had to bring in the other jurors to see if they witnessed that interaction and felt that it might have unduly influenced. I mean, it's not a small thing. And for her to go about giving her opinion on this case to the jurors, I'll add to that, everybody, because one of the jurors did say it influenced her. And this Judge Toll, I don't know much about this judge, but this judge did not seem to care. Judge Toll said, fine, it was bad. She did a bad thing. The jurors heard it, but I'm going to say that it didn't influence their verdict. Okay. I think this thing's coming back. I really think about it. If you are the Supreme Court of South Carolina, what precedent are you setting here? Are you setting a precedent that even when jurors say they were influenced by outside influences, even in part in their deliberations, that's not a problem? That's not a very comfortable precedent to be setting. He could get a new trial on this thing. Mark my words. And then if he does, you will be seeing me, Taylor, down in South Carolina. All right. Thank you so much for that question. A case we haven't talked about in a while. All right. Where are we off to next here?
Hello, Josh and CC crew. This is Misbehaving from San Diego. This week's question is brought to you courtesy of Letecia Stauch. Should she get a new trial? Does she get the right to a speedy trial? Or is there already a time frame set for the retrial of a person already incarcerated? Or would this take precedence over cases already on the docket? Diolch yn fawr, which means thank you very much in Welsh. Ta-ra now.
Thank you, Misbehaving from San Diego, England. Appreciate you putting you on the map. It's so funny how these questions are lining up today, that they all kind of fit together as far as a general theme. But yeah, we're talking about Letecia Stauch in this case. She was granted a new trial by the Supreme Court of Colorado, right? Am I getting that right? Colorado, because of something to do with the jury. I'm telling you, this is something that the appellate courts take most seriously, is anything to do with the jury. One of the main arguments on appeal, and one of the main arguments that is granted on appeal, is when the jury is improperly instructed. That alone, think about that. The instructions, something that like nobody seems to be listening to anyways. But if those instructions are improper, that is grounds for appeal. We're so concerned with what the jury is being told. Now, if the jury does whatever they wanted to do, fine. We just want to make sure that whatever they were told was proper. So their instructions, the interactions that they have with the attorneys or courtroom staff, and in this case, even their association with anybody who might be involved in that trial. She was granted a new trial because one of the jurors said that their son-in-law was a prosecutor. Never talked to that person about the case, wasn't bothered by that person, wasn't even working on the case, just happened to be in the same office. Like a totally attenuated connection. But there's a statute in Colorado that says if it's even a third-degree relationship, they must go. And the judge didn't release that juror. We don't know if that juror was influenced, if that juror influenced others. Whole new trial because of that very small issue. And that's why I'm saying, mark my words, Alec may be back in court one day, which would be a miscarriage. But you don't yell at me and don't yell at him. Yell at, what's her name? Becky Hill. Anyhow, that's not what you're asking, Misbehaving. You're asking about Letecia Stauch and will she get a speedy trial the second time around? All the rights apply. You start brand new. Everything applies. You get a brand new prelim. You get a brand new judge. You could get a new judge, but you get brand new rulings. Even if it's the same judge, by the way, you get new rulings on all your evidence. Everything comes up again. It's brand new, fresh start, carte blanche. You are starting fresh, and that includes all of your attendant rights. So you have a right to a speedy trial. Yes, she could rush this thing if she wanted to the second time around. I don't think she's going to, because I think she's probably hopeful she might convince a jury that she was insane this second time around, but buckle up. It's going to be a long ride in my view. All right. Mel's mom, not M. Littles. Thank you so much. How many other trials did Becky Hill mess up? Great question. If I'm a defense attorney out there, I'm probably trying to find out, right? I am sure there are a whole bunch of defense attorneys out there trying to get a hold of jurors on previous trials and wondering how much Becky Hill spoke to them. Really great question. Heather Cooper Smith, thank you again for the super sticker. That's so kind of you. Mel's mom, not M. Littles, back again, says, I would love to see a live with Josh and Tiff. Well, you can see a live with Josh and Tiff if you're part of our membership program. And I will tell you, we just did that, in fact, 2 days ago. We'll talk a little bit more about that later. Stay tuned to the end for announcements. Don't go anywhere. But in the meantime, let me get to our next question here.
Good morning, Joshua, Tiff, Caitlin. Ain't no hollaback girl here. Joshua, high-profile defense attorney Diane Menashe is currently contemplating presenting a defense of temporary insanity on behalf of Michael McKee. Curious as to what your thoughts are. I don't personally feel that this is going to fly with the jury. I also wanted to comment on the defense team for Kouri Richins, who have just filed a motion to push back on the current sentencing date of May 13th to June 15th, which is their wedding anniversary date. They're citing that they need more prep time for mitigating evidence. And I am curious as to why this wasn't already done in the closing statements. And if they are indeed able to do this, can the prosecutor then present a rebuttal? I just think that she should be focusing on a remorseful statement to the Richins family, as opposed to primping herself about all the certificate courses she's been taking while in detention. Thank you. Bye-bye.
ANHBG from Kawartha, Ontario, Canada. Thank you so much for calling in. Another great question. So I have seen these rumors, and I did a lot of looking into. This is talking about the Michael McKee case, the murder of the Tepes out of Indiana. There was reporting that Ohio, I think. There was reporting that, wait a minute, am I wrong in that? Was it Ohio or Indiana? It's Ohio, sorry. That Diane Monash, who is his attorney, Michael McKee's attorney, will be raising a NGI defense. I don't think that's true. I think where this is coming from is Brian Enton, who I like a lot. I'm a big fan of his. Did an interview with a legal expert who said there's the possibility that this could be a defense, and that kind of got cannibalized by some other folks who said, oh, that's what they're going to do. I don't think she's never indicated that in court in anything that I could find. And I don't think that that's going to be true at all. And by the way, I think it's a horrible defense if that's what they want to bring. If that's in fact what they're going to argue, good luck with that one, because the amount of planning that he put into this is extraordinary. That is not where you bring up an NGI. Temporary insanity, lost his mind, whatever. Not going to fly with jurors when you got the amount of planning that he put into this whole thing. So I don't think that will come up. And to answer your question, if it does come up, I think it's a loser of an argument. To your question though about Kouri Richins, this was interesting to me, and I had not heard this, but you're absolutely right. So right now, the sentencing is set for May 13th, May 18th, May 13th. Okay. Which is Eric's birthday. And people quickly realized that afterwards. And we all thought, my suspicion was that his family, when asking for, is there a date in May that works for you? Pick that date. Prosecution said, sounds good to me. Court says, okay. Defense says, okay. And then they realized afterwards, oh my God, that's Eric's birthday. We cannot have this sentencing on his birthday. It's going to create far too much of an emotional environment. And that's not going to help us. This is Kouri's team, I imagining having this conversation, which is interesting that Kouri didn't immediately recognize the date. Now, she probably had bigger things on her mind, having just heard that she was found guilty of murder. So they go back. We actually talked to Sky Lazaro about this on our channel. And Sky was like, they're never going to show up for that date. Well, surprise, surprise, they're asking to move that date to a later date. And they're saying that's because they need to put together further mitigation. Fine, whatever. I agree with you. Ain't no hollaback girl, by the way. What is that going to be? A bunch of classes she took in jail. But the judge is probably going to give it to him. Probably going to give them some more time to do that. I think, by the way, the judge should do that, because I think setting it on his birthday probably will create an unfair environment. And by the way, you don't want to do that. You've got this case across the finish line. Don't mess it up now with creating some appealable issue. But then the date that they suggest is June 15th, which is in fact the anniversary of their wedding. Now, are you telling me Kouri didn't realize that as well? Or is this on purpose? And what kind of diabolical reason do you want to put it on the date that you guys got married? Is she going to somehow bring that up in a statement to the court? And by the way, this is our, and I've lost the love of my life, and this is the anniversary of when we got married. Like, I just think that I think we need to find a date that avoids all of these issues. I do not think that was an accident. I do not think her attorneys were saying, okay, well, okay, yeah, it's Eric's birthday. Let's pick another date. What do you like in June? June 15th. Yeah, that works for me. And she doesn't go, oh, by the way, that's our anniversary. Dudes may forget anniversaries. In my experience, the ladies usually do not. Thank you so much, Ain't No Hollaback Girl from Kawartha for the question. Shy Gal says, hi, everyone. Please hit the like button for Josh. Yeah, hit that like button, everybody. Thank you so much, Shy Gal, for reminding us. Seeking Justice says, please hit the like for Josh. Yeah, is nobody liking this? What's going on? Thank you guys so much for the comments. Cancer Free, congratulations. Member for 15 months. Happy crewversary. I may lurk more than chat, but love it here so much. Oh, well, we love having you here, and we're appreciating that you even popped up to say that. All right, let's keep it rolling. Where am I at?
Hey, Josh. Hey, Courtroom Confidentials. Good to see you guys. This is Lisa Shelton, aka Bluebird 711 from Waddy, Kentucky. Glad to be back. Missed you guys. Anyway, my questions are about the D4VD case. I was just wondering if the wording clearly indicates that there was already an ongoing investigation prior to this concerning Celeste and her age. I know the obvious answer would seem to be yes, but when dealing with statutes and laws and legal speak in other states, just want to make sure. Also, concerning the death penalty, I know that people are saying, well, his young age is a factor, blah, blah, blah. But why does the court even look at that, considering the heinous nature of the crimes? Also, which offense in the included crimes do you think would call for death penalty? I didn't even know they did death penalty in California. I think it's so rare, but maybe I just don't know enough about the state. Anyway, God bless you guys. Have a great Sunday, and I will see you in chat.
Lisa from Waddy, Kentucky. Let's put Waddy on the map. Thank you so much for calling in, Lisa. Good to hear from you. Can we get a final ruling on this? Are we going with David or are we going with D4VD? David. Okay. I'm hearing David from the crack team of producers and investigative journalists working behind the scenes here at Courtroom Confidential. But then, I think the chat should weigh in on this as well. I say David. I say David just for the ease of saying it, by the way. David says Ms. Tiff Ritter. Just David, says Teresa Arsos. Okay, we'll go with David. And Kaylin is invoking her powers as a Gen Z representative to say it's just David. Okay, great question though, Lisa, about was she already a witness to an investigation? This is another one that's been causing some confusion amongst people. So just so everybody knows what he was charged with. He was charged with first-degree murder. Then he was also that's count 1. Count 2 is assault of a minor. And count 3 is mutilation of a body. Okay. Count 1, though, has some special allegations attached to it, what are called special circumstances. They are not individual crimes. They are special circumstances. attached to the murder. In other jurisdictions, they call these aggravating factors. The special circumstances here are 1, lying in wait, 2, for financial gain, and 3, murder of a witness to an investigation. That phraseology, those words are taken from the statute. So they're quoting specifically from the statute, okay? And they're fitting the facts of this murder into those special circumstances. So lying in wait, what does that mean? We've talked about that quite a bit on other shows on this channel, but it means just an extra amount of premeditation. That you didn't just think about it, but you planned ahead. You lured that person. You had intentions of murdering that person well in advance. That is, quote unquote, lying in wait. Financial gain. Does that mean that you have to have immediately profited? That, it's an insurance scam? It can be, but it can also be to protect your financial interests. So their argument here is that he was a up-and-coming performing artist. He had, in fact, released his album 2 days after her murder. He was trying to protect his career and therefore keep her silent. That's the financial gain. And then the last one is witness to an investigation. People have gone, wait a minute, was she already telling him? Was there already an investigation? No. Their theory is that she was going to say something. And that's what could get interesting. Is there a text exchange? Is there a witness to a conversation where she's saying something along the lines of, I'm going to tell everybody about us? And that makes her a potential witness to an investigation of what crime? The crime of the assault of her as a minor. He had been carrying on a sexual relationship with her. She was a minor. She was going to expose him, making herself a witness to an investigation, not a current investigation, but a potential future investigation. And therefore, that is the satisfying of that third special circumstance. By the way, they don't have to prove all 3 of them. They just have to prove one of them. As long as they prove one of them and the jurors find that to be true, he's on the hook for a special circ murder, which makes him eligible for life without parole or even the death penalty. As far as taking into consideration his age, the DA's office in deciding whether or not to to actually pursue the death penalty in this case, yeah, they will. They will take that into consideration. They'll take into consideration many different factors. His age, his lack of a criminal history. Doesn't sound like he has any prior convictions. His upbringing, his background, a bunch of different things will be taken into consideration, and they're going to balance it all out. They're going to balance all of that, quote unquote, mitigating circumstances against the aggravating circumstances of how horrific this murder is, and the age of the victim and the vulnerability of the victim and all these things. And they take this very seriously. They convene an entire committee and they have meetings with many people to decide whether or not to pursue this. In my experience, the DA's office in Los Angeles is very mindful. They are not, they don't pursue the death penalty only in the most egregious of cases. So we'll see what happens in this one. Thank you so much, Lisa, for asking that so that we could clear up those issues. Appreciate you. All right. Let's get to who is next on our list here.
Hi, Joss and everyone. This is Berna, a first-time caller from Chattanooga, Tennessee. I have 3 questions. First, about the death penalty. If someone pleads guilty to a serious crime to avoid all the gory details of a trial, can they still be sentenced to death in a state where that's allowed without any trial? Second, what's the difference, if there is, between a lawyer who lost their license and one who's disbarred? And can that poor lawyer, ex-lawyer, ever practice again, like, for instance, by retaking the bar exam? And then third question, in the Gerhardt Konig case in Hawaii, some people wondered if he could be deported since he's a naturalized citizen from South Africa. Being a naturalized citizen myself, I always understood that when you become a citizen, you renounce alliance to your previous country unless you have dual citizenship. So I was just wondering if you can be deported. And then I am so super excited to meet you all at CrimeCon, and no pressure, but if you have stickers or magnets, I will definitely buy some. Okay, bye.
No pressure at all. We do have stickers. You're getting one, Berna. We don't have magnets, but we do have pins. I hope that satisfies as well. Please stop by. Would love to say hello to you. And I'm glad that you cleared that up, because when I first heard that you were from Chattanooga, your accent did throw me off. I thought, what kind of Tennessee accent is that? I've never heard. Some deep part of Chattanooga, apparently, but no. But thank you so much, Berna, for calling in and for being a first-time caller. Always love that. Great questions. Okay, let's get into them. Can someone be sentenced to the death penalty when they take a plea and don't have a trial? The answer is yes. We have seen that more than once. Remember, Nicholas Cruz took a plea, pled guilty to the crimes involved in the Florida mass shooting, and he only had a trial on the penalty phase, deciding whether or not he would be sentenced to death. He was not sentenced to death. They could not get a unanimous verdict from those jurors. And in fact, they changed the laws in Florida in reaction to that. They felt that that was a miscarriage of justice. There's a current case going on right now out of Texas. Really horrific circumstances of that case. I don't even want to mention the person's name, but he is on trial for the penalty phase. He is admitted to the murder and admitted to the circumstances that make him death penalty eligible. He's just having a trial on the circumstances of whether or not he should be sentenced to death or not. So yes, you don't have to have a trial on guilt to have a trial on the penalty phase of a case. So we've seen that more than once, and the answer is yes, you can be. Getting to your question about losing your license or being disbarred, there is a difference. Disbarred is where you have done something that have violated the rules of the bar, the ethical rules, financial obligations, everything else. There's a lot of rules attorneys have to follow, and they have decided to remove your license from you against your own will. You've probably fought it. You've had hearings about this. By the way, it's very rare. You'd be surprised at how bad attorneys have to mess up before they actually get disbarred. Usually they might have their license suspended for a period of time, but to actually be disbarred it doesn't happen all that often, and it's usually very egregious. But you can lose your license by just not paying your dues. If you just don't practice and don't pay your dues, you could just lose your license, like you can lose your license to practice, in any other kind of professional context. Getting it back in certain circumstances, not as difficult. It might be, satisfying certain obligations, paying back on your dues. You can get your license back. Getting your license back after being disbarred, I don't know if it's impossible, but I know it's very difficult, because usually by the time they've arrived at disbarring someone, they've been given several chances. They've suspended their license for a period of time. They've, it's kind of one of those 3 strikes and you're out sort of thing. And I think by the time you get disbarred, there's probably no coming back. And it's usually something like you've committed a crime and you're just not eligible to practice law anymore. And then to your question about a naturalized citizen being deported, I am no immigration expert, but my gut tells me that as a naturalized citizen, you have all of the same rights as a citizen, and those include the right to be convicted of a felony and not get deported. So I think you were talking about Gerhardt Konig. He will serve his time and then not be deported because he's considered a citizen and enjoys all the same rights of citizenry. Thank you so much, Berna from Chattanooga, for asking those questions, though. All really, really good ones, and we're glad that you decided to call in. All right. Let's keep it rolling. What am I doing here? Why do I feel lost? Oh, no.
Hey, Josh, Tiff, and CC chat. This is Allie B from Tennessee again. There's a girl named Christa Pike, who is in the prison here in Nashville, where I volunteered for 2.5 years through an organization called God Behind Bars. Long story short, she has a sentence date for her execution because she got the death penalty that's happening in September. And she's very evil, very, very evil. I can't hardly look at her story. It's truly terrifying and sadistic. But I'm curious, Josh, if you have ever had a case where you had to sit in and watch one of your clients be sentenced to death in that little room. I don't know if I could do it. So anyway, I just keep seeing articles locally about it. And I did meet her one time and I couldn't stay around her very long because she terrified me. But anyway, just curious. Sorry, my brain's everywhere. Bye.
Allie B from Tennessee. Let's put you on the map. So good to hear from you. Thank you so much for asking these questions. First, no, I have never had a client sentenced to death. That is not because I'm a fantastic lawyer. That's because I've never, as a defense attorney, worked on a death penalty case. I probably would not, to be quite honest with you. That is some heavy duty stuff. And you know, that's a special breed of defense attorney who involve themselves in that. And I mean that with utmost respect. I mean, they have an incredible responsibility to handle those types of very serious, very complex cases. So no, I don't know what that's like. And in fact, I was trying to think of anybody I know who's ever dealt with that is, you know, been a part of even a client being executed. Heavy duty stuff. I've worked on death penalty cases as a prosecutor, but you know, never on a case where the actual execution has even been carried out. Here in California, as you know, they're operating under a moratorium. Anyhow, getting to the case of Christa Pike. I had not heard of this one. So I did a little research on this. I will tell you it's graphic. I'll just warn you guys ahead of time. It's not overly graphic, but it's disturbing. She holds the distinction of being one of the youngest women ever sentenced to death row. She was 18 years old at the time that she committed this horrific crime. And she is lined up right now as things stand to actually have her sentence carried out in September of this year. So that's quickly approaching, I imagine, in her mind and in the minds of her defense team. She's accused of killing 19-year-old Colleen Slemmer. This took place back in January of 1995, back in Knoxville, Tennessee. Story goes that Christa felt that Colleen was trying to steal her boyfriend. Her boyfriend was, his name is Tedarrell Shipp. So she, Christa, along with Tedarrell and her friend Sadola Peterson, all kids, by the way, barely 18 years old, lured Colleen out to a sort of secluded area under the guise of trying to make peace over this disagreement that they were having. And then she proceeded to torture her for the next 30 minutes. She tortured her, she beat her, she carved a pentagram into her chest, and then she smashed her skull in with a block of asphalt. And then, because she was so proud of what she had done, she took a piece of that skull and carried it with her, showing it off to people for the next few days until she was eventually apprehended and arrested for the murder. Evil is the right word. 18 years old to commit this kind of a brutal, brutal murder. Yeah, and she was sentenced to death, and she's been on death row since that time. This was, like I said, back in the late 90s. And she's now exhausted all of her appeals. And I think the only thing available to her at this point is some sort of petition to the governor to step in and intervene. And we'll see if that actually takes place. Horrific stuff. God, there's so many of these things that come up that you've never heard of, and they're just nightmarish. Thank you so much, Ali B, though, for asking this excellent question from Tennessee. We appreciate you, and please keep calling in. All right. Where are we at? Here we go.
Hi, Josh, and hi, Tiff, and hi, Mods and CC crew. My name is Oh My Tosh, and I am a first-time caller calling in from Dublin, Ireland. And if my accent is still a mystery to you, it's because I am Polish. And if I were to call in from my hometown, it would have been Poznań. I wonder if it's on the map. If no, I hope that changes soon. Yeah, so my question is, what's an investigative grand jury? What do they investigate? What do they decide? How do they aid investigations? Yeah, I understand grand jury, the regular grand jury. They are presented evidence, and then they determine if there is enough probable cause to file charges against someone. But what decisions do investigative grand juries have to come to, or have to make? Yeah. So, and also, how often do they actually meet? Because I heard they can meet every couple of weeks. What do they do in between sessions of proceedings? Yeah, I'm running out of time, so I hope you can answer my question, and I hope to be calling in soon with more questions in the future. Bye.
Oh My Tosh from Dublin, Ireland, but not originally. Everybody's throwing me off with the accents today. Oh My Tosh, originally from Poland, but now in Dublin, Ireland. Thank you so much for calling in. Appreciate hearing from you. And a first-time caller. Thank you for that. Please call in again. I'm glad you asked this, because this does confuse some people. What is an investigative grand jury? The grand jury is a group of people who receive a summons, like most people do for a jury summons, except they find out that their jury summons is not for a particular trial, but is to serve on the grand jury. Now, usually these are people who have much more either paid time from their employer. Many times it's retired folks who have the opportunity to serve on a grand jury, because you serve on a grand jury for longer than, like I said, one trial. It could be for a matter of weeks. Sometimes I think it's about 3 months at the far end. And you're not sitting on one particular issue. It can be many things are brought before the grand jury. It could be you're asked to listen to evidence on a particular case and return an indictment or not. Or it could be that you're asked to listen to evidence where they're not asking you to return an indictment, but you're listening to evidence being put on the record under oath. It really depends on the purpose that you're being asked to serve. Now, why do they have this? Well, because they need another mechanism to accomplish a couple of things. One, sometimes they want an indictment without going through the prelim process in open court. They might do it because they want it to be secretive. They don't want it getting out that a person is under investigation. Or it might be incredibly complex, and to put on the prelim would take far too long and be a logistic nightmare, because they can put on a certain amount of witnesses on a grand jury, and while that grand jury is still sitting, a week or two later, put on more witnesses on that same grand jury, while that grand jury has in the meantime handled other things. They're just a body of people serving for a certain period of time, handling whatever business that the prosecution has during that time. The reason why you talk about convening a grand jury, though, is that if you're going to, especially in this situation, if you're going to ask them to return an indictment, it needs to be the same group of people. In other words, you can't present 6 witnesses to one grand jury group and then 6 witnesses to another grand jury group and ask that group to return an indictment. They haven't heard everything. So if you're going to ask a jury to return an indictment, it has to be the same grand jury. You got to get all the witnesses in front of that same grand jury. But if you're only using the jury for investigative purposes, it doesn't necessarily need to be the same people. And in fact, in the David case, or the D4VD, depending on where you stand on that issue, they convened 3 different grand juries. That's because it took place over a long period of time. So they presented some witnesses in front of one, some witnesses in front of the other, some witnesses in front of the third, and they didn't ask for a return on an indictment because they were simply doing it for investigative purposes. Why, you say, then do they even need the grand jury if they're not going to be asked to return an indictment? Because you cannot depose people in a criminal context. There is no mechanism for that. You cannot force people to speak in a criminal context. If a cop shows up at your door and says, I want to talk to you, you can say, thanks, but no thanks. What you can't do, though, is ignore a grand jury subpoena. If you're given a grand jury subpoena, you have to show up. And if you show up and you say, I don't want to say anything, a judge can be brought in to grant you immunity for the purposes of testifying so that you can't say I have a Fifth Amendment issue at play, and you are then compelled to testify. And if you don't, you can be found in contempt and locked up even. So it's a very powerful tool for prosecutors to force people to speak. And there's really no other tool available to them for that same kind of aggressive purpose. It is rarely used for that purpose. But in some instances, like in this case, they feel it's important enough. So that's what is happening here. They convened more than one grand jury. They presented witnesses in front of each of those. And at the end of the day, they didn't ask for an indictment because that's not why they convened them. They convened them to put people under oath on the record and get their testimony. And that's why I feel somebody said something in this grand jury that was enough to convince them to go out and arrest David and lock him up and then charge him like they would any other person that had been arrested. He got arrested on a Thursday, charged on a Monday, arraigned on a Monday, and now his defense team is barreling towards his prelim, which may take place next week. Does that make sense? Did I lose anybody? Did you all fall asleep? Do you all feel good about that? I hope that makes sense to everybody. That's what's happening here. It's kind of some advanced level prosecutorial work, and I really applaud it because it doesn't happen all that often. And I'm glad that they did it in this case because they felt it was necessary. All right. Allie B from Tennessee, I've heard, I feel like we've talked already today, says she is now complaining about the pain she will experience because of needles, and it infuriates me because Colleen suffered. That is... Talk about chutzpah. That is pretty incredible. The pain of the needles. Wow. Yeah. Thank you for bringing that one up. Seeking Justice, thank you so much for supporting the mods with coffees. Appreciate you. Long Island Hillbilly says, thank you for your excellent work. Wow. Thank you so much for your generous support, Long Island Hillbilly. Appreciate you. All right. Let's keep it rolling. Shall we? We shall.
Hey, y'all. Court Dog Daniel here. Josh, you say David. I say D4VD. Whatever. I read Celeste's entire autopsy report, and one detail on that report really struck me, which I haven't seen mentioned on any broadcast so far. And that is that she still had braces on her upper and lower teeth. That just hits me differently. A young girl's normal life interrupted and taken, and it made the whole thing feel very real in a way you can't really shake. And it brings me to my question. When you come out of law school and step into this work, you're suddenly exposed to details like this, things most people never encounter. So I'm curious, as an attorney, what was that transition like for you? How do you go from not being exposed to that kind of reality to being able to process it, handle it, and still do your job at a high level? Thanks for your answer. 33 days till Crime Con. Juice for justice for Celeste.
Love it. Love it. 33 days, fully juiced. Court Dog Daniel from New Britain, Connecticut, always running on 100% juicery. I appreciate you, and a great question. David, official ruling from the counsel here at Courtroom Confidential, as we're going to refer to him as David, and you're right. The autopsy had some very disturbing revelations beyond the fact that her body was dismembered and mutilated and treated like absolute garbage. She, yes, still had braces. She was a child. This is a murder of a child, and that's the way that we should talk about it. He murdered a child. She was 14 years old. Now, we know that now. Before, we didn't even know how old she was when she was killed. Now they have a date, and according to the prosecution, he was 14 years old when he murdered her because he had been assaulting her and she was going to say something about it. When you think about it that way, can you imagine a more horrific crime that a person took about systematically assaulting a child, and then when that child says, I'm going to say something, you murder that child, chop them up and throw them in the trunk of a car? These are the types of cases that, by the way, prosecutors do decide to pursue the death penalty. So don't be surprised in this one. Another detail on this, and I hesitate to talk about it, but I know that there's been a little bit of reporting about it. Her fingers had been removed on one hand. And apparently one of those tattoos on one of those fingers was his name. Was that part of his really amateurish and stupid effort to cover up his involvement with her? Who knows? We'll see. Some really disturbing stuff if you want to take the time to go through that entire autopsy. To your question, what was it like being I wasn't even a lawyer at the time, by the way, when I started getting exposed to this stuff, which may explain the person that I am today, but I was a law clerk still in law school when I started working in the DA's office. And when I got to the major crimes division as a law clerk, that is the worst of the worst stuff. That's where this case, by the way, is being prosecuted, is out of the major crimes unit in the DA's office here in Los Angeles. And there are cases that are nightmares that you can't get out of your head that don't even make the headlines. One of the first cases I worked on, I've talked about this in past episodes, and I think I even got into the gory details of it on a members only live, is the case of Kevin Graff. That means anything to anybody. And in that case, I'm going through the crime scene photos, and one of the photos is of a human head placed perfectly and cleanly on the bedspread of a newly made bed. That image is one that does not get out of your head very quickly. One of the other cases I worked on was an elderly couple who had been beaten to death with a, I guess I should have told you guys this was a little bit graphic, but had been beaten to death with a tire iron. And by the way, that's not a quick death either. Stuff that you think is one or two blows because we watch movies and we think that's how it happens is not. Some of these deaths are not as quick and painless as you might imagine they are. And that one certainly wasn't. So yes, you are exposed to these things early on. I will say that you quickly find out what you can handle and what you can't. But there is a compartmentalization that starts to take over where you also realize I'm doing a job and this is evidence. And I need to understand how to use this to prove something. And you start to become a little bit mechanical about it. Anyhow, great question, Court Dog Daniel. Appreciate you, my friend. All right. Get the hankies out, everybody. We're down to the final three. God, we had some great questions today. And we've been all over the map, by the way. Ireland and Marshall Islands and Egypt. Great questions. You guys really came through this week. All right, let's finish it out, though, in the few minutes that we have left here. Where am I? Here we go. All right.
Hi, everybody. This is Sonia from Chicago. Happy Sunday Fun Day to everybody. So my question is regarding evidentiary standards and burdens of proof. So specifically in David or D4VD, I could think of some other names, but I won't say them here. So is there any difference in the standard burden of proof between a prelim and a grand jury? You know how they say, a grand jury can indict a ham sandwich. Is it true in front of the judge? Is it the same standard? Are they delivering the same type of evidence? Really, really interested in your answer. Look forward to seeing everybody. Bye, guys. Thank you so much, Josh.
Sonia. Always great to hear from you. Sonia from Chicago, Illinois, putting you on the map. David, we decided once again, I love how this is like an ongoing thing. Is there a difference in the standard of proof between a prelim and a grand jury? This is a great question because you do hear people talk about a grand jury and how easy it is to indict and how the saying goes, you could indict a ham sandwich. So is that the same standard of proof that we're dealing with at a prelim? The answer is yes and no. The answer is, strictly speaking, it's the same standard. It's probable cause. The question being put in front of a grand jury is the same question that's being put in front of a judge at a prelim. Is there probable cause to believe that this person committed this crime on this date and therefore should be held to answer at trial? It is a very low standard, by the way. Even in front of a judge, it's a low standard. But why do we feel that somehow the grand jury is easier? And the reason for that is that the grand jury is not an adversarial environment. The grand jury, the defense and the defendant are not present, nor do they have a right to be present. So because of that, the prosecutor has to wear two hats to some extent. The prosecutor is supposed to present obvious exculpatory evidence. But that doesn't mean that the prosecutor has to present all arguments that a defense attorney might make at the prelim. And the prosecutor is not required to cross-examine the witnesses. The witnesses are just kind of testifying under direct. And there's not that same scrutiny that the witness might fall under cross-examination. And that's why people make that. It's not true, but they make that statement that, listen, if the prosecution really wants to get an indictment, they probably can, because they're not really, it's like playing with where there's no defense on the other side. Now, that can create issues if they're completely unfair. You can attack the indictment and say this obvious kind of defense issue, the fact that there's an alibi was not presented in front of the grand jury. But you'd be surprised at how many times the judges say, well, this is only a probable cause hearing and we're still going to allow the indictment to stand. But at a prelim, you've got the defense there. The defense can raise objections. The defense can cross-examine. The defense can put on their own witnesses. The defense can make arguments. And that's why sometimes it's a little bit more difficult at a prelim. But the answer is it's the same standard of proof. Great question, Sonia. I'm glad that you asked that because we have an opportunity to kind of explain that. And we put up the David case here. His defense, Blair Burke, is saying, wow, that was all done in secret and not under the light of day and everything else. She's missing the fact that they didn't indict him from that. That was just an investigatory tool. They're going to go to a prelim on this case. And she's saying, well, we want it right away. Well, I'm telling you, I know that there are pundits out there who are saying this is a real smart move on the part of the defense. I do not think so. I do not think so. It is very fun to play tough when it's not your butt going to prison. It's like you're gambling with other people's money and acting like you're rich. Pump the brakes. Do this the right way. All right. Thank you so much, Sonia.
Hi, Josh and the Courtroom Confidential family. Love your show. And I'm a first-time caller. My name is Dara Kaplan, and I'm from Washington, D.C. You can put D.C. on your map. I'm wondering if you already have D.C. on your map. But anyways, my question is about the Tepe murders. I'm wondering about the dog. What happened to the dog? And why didn't the dog bark and wake everyone up? I haven't heard anything about this in all the podcasts I listen to. So I would appreciate a discussion about that. Thank you so much.
Thank you so much, Dara from Washington, D.C. And I think you are our first caller from Washington, D.C. I know that we've got close by neighbors, but I don't know if anybody properly from Washington, D.C. has called in before. So thank you so much. Putting the capital on the map there, Dara. And for being a first-time caller, always love that. Thank you so much for jumping into the conversation. Talking about the Tepe murders. What did happen to the dog? Great question. It kind of got overlooked in all of this, but there was a dog present. Answer is, I don't know. Answer is, we don't know if the dog is maybe just one of those dogs that didn't bark. Maybe one of those dogs that that kind of cowered through this whole thing. Maybe not all that alert of a watchdog. I don't know. Obviously, the dog didn't cause problems allegedly for Michael McKee to commit this murder, double homicide. The other thing is the dog could have barked and we would never know. I mean, remember, the only other witnesses to this crime are a 1 and a 4-year-old who were trapped inside of that house. So who knows? Maybe the dog was barking. Maybe it did wake them up. Maybe that they just didn't alert anyone. Didn't talk about the dog. I mean, you know, these poor little babies were in that house for who knows how long, crying, nobody coming, you know, scared and hungry and everything else. Just what a horrible, horrible situation. Horrific human being. I know it's all alleged, but if we're going off of the allegations, this is a horrific crime. But great question. I imagine we're going to find out what, you know, was the dog even like tracking through their blood? I don't know. I said I didn't want to get graphic and then I just did, but great question, Dara from Washington, D.C. And I'm glad that you brought that up. This one will be coming back to court, I think, soon. So we will continue to follow that one. I know it's important to all of you. All right. Take a deep breath. It's the last question of the day. And this is a good one. Before we get into this one, I have to kind of catch you up on a previous Sunday Fun Day, because this was great. Mandy from Wexford, Ireland called in, I think it was last week or the week before. And Mandy told us that there is a program in her community where you can contribute for a small fee to have a local stray cat neutered, and part of the program to help, keep the stray cat population down so that they're healthy and not running amok, and they don't have to, I don't know, do something worse with, a bunch of stray cats. They will allow you to contribute for the small cost of having a cat trapped and neutered. And part of the benefit is you get to name that cat. And Mandy was curious about Gerhardt Konig and how many times he mentioned his own testicles in his testimony. And she thought it might be clever to contribute some Gerhardt cats in her community, since he seemed to be so concerned with his testicles. It was hilarious, and we all enjoyed it. Well, Mandy didn't just enjoy it, she followed through on it. So here's the latest update from Mandy.
Hi, this is Mandy here from County Wexford in Ireland with a little update on that testicular case. So as promised, I donated €100 to the Arklow Cat Rescue, because that is where I got my cat, Seamus, for 16 cats to be named, 16 versions of the name Gerhardt. By the way, thank you to Ain't No Hollaback Girl and Tiff Knox for counting on that one. I also donated for 4D polls in case some of the cats really hate the name. The rescue sent me a letter which I forwarded to the CC Crew email in case some of you want to name cats as well. And please do, it's a really worthy cause. And I'll read a bit of that now, if I may. It says, thank you for your generous support of our TNR program. As part of this initiative, you're now sponsoring the Gerhardt 16, a distinguished and occasionally disreputable group of local tomcats. Each cat in this program will be humanely trapped, neutered, and returned to their territory under our care. In the event that any of the Gerhardt 16 are later socialized and rehomed, they may apply for a complete change of identity under our entirely unofficial witness protection scheme. A limited number of sponsored deed poll donations are available to facilitate this transition into respectable domestic life. All such changes will, of course, be handled with utmost discretion. Your support helps to ensure that these cats live healthier lives and directly contributes to reducing the feral population in a humane and effective way. With sincere thanks, Paula Fagan, Arklow Cat Rescue. There you have it. Slongo.
I love this. Let's put up the letter. Well, there's Mandy in Wexford, Ireland. Thank you so much. We're putting you on the map, but she did send us the letter. I want to put up the letter. She read most of it, I think all of it to you. I think this is amazing. Mandy, you're fantastic. It's such a wonderful cause that you donated to. 2, your humor is not lost, and I love that you followed through on this. And then 3, I got to give a shout out to whoever is the program director that wrote you this letter, because it is so perfect. You are now sponsoring the Gerhardt 16, a distinguished and occasionally disreputable group of local tomcats. This had me laughing so hard. What was the other part that got me cracking up? Oh, here. In the event that any of the Gerhardt 16 are later socialized and rehomed, they may apply for a complete change of identity under our entirely unofficial witness protection scheme. These people are fantastic. Mandy's fantastic. And I just love, and I hope it gets back to him somehow, that there are 16 versions of Gerhardt running around. Some of them are there. Gerhardt, Gerhard, Gerard, Gerand, Gary, Gerald. This is fantastic. This is such good stuff. Oh, and you're in the chat. Thank you, Mandy. Love this. Love this so much. Thank you for closing us out with this. Put a smile on our face. opportunity. Mandy, you are the best. This is just great. All right. Don't go anywhere. Let me give you guys some quick announcements, and then I'll get you on with the rest of your Sunday. First of all, let me tell you about a little website that I hope that you check out. It's called thecourtroomconfidential.com. If you listen to the messages today and you thought those were all fantastic, but I want to leave one, well, the easiest way to do that is go to thecourtroomconfidential.com and click on leave us a message, and we will answer your question at the next Sunday Fun Day. 2, membership. A lot of you received gifted memberships. We thank you, everybody, for your support in gifting those memberships, including Best Nancy for gifting a membership. If you didn't receive one and you want to become a member, then do like McKenna Pate and go to thecourtroomconfidential.com and click on become a member, and you can join the crew. Do like Wendy Weckerly just did and become a member as well. We would love to have you. Hullabaloo just became a YouTube member. Thank you so much for jumping on board. And Misbehavin' has been a member for 5 months. Happy crewversary. Say, making Josh say, bring the jury for Judge Newman. The other thing that you will find on thecourtroomconfidential.com is merch. If you like this shirt, I am sure that Kaylin will say that it's called Chalky Mint. It actually might be Chalky Mint. I'm not sure. Committed Mint, get it? If you like this shirt or any of the other colors that we have available, we've got you covered. Alicia K. Mayo says CC Mintbership has its privileges. Very nice. We've got shirts. We've got mugs. We've got tumblers. We've got notebooks. We've got hats. We've got zip-up hoodies. We've got pullover hoodies. We've got quarter zips. We've got you covered for everything that you could possibly want at the shop at thecourtroomconfidential.com, including pajama pants. Yes, even pajama pants. So please check it all out at thecourtroomconfidential.com. What did you miss? Well, earlier this week on Friday, we had our weekly roundup where we talked about all the cases that were in court this week, including David and Caleb Flynn. And we introduced our brand new series, the Hero of the Week, that we're going to highlight somebody every single week. So please check that out. I'm not going to tell you who the Hero of the Week was. You'll have to go check it out. We're very happy for who was nominated and who won this week. So please go check it out. The Crafty RN has been a member for 8 months. Happy Crewversary says, I wish appeals were only allowed for innocents. Yeah, if only we could know that. Happy Crewversary to Garden Girl says, celebrating catching a Sunday Fun Day live. Love to all. Glad that you were here live. And to Farm Girl, member for 20 months. I'm going to leave my message. Are you? Ooh, challenge accepted. And on Friday, right after our weekly roundup, we had our members only live for the month. And this was a special one because we did something different. We did a Ask Me Anything. And somebody earlier said, when are you and Tiffany going to do a live together? Well, we did one together side by side, answering all the questions that you guys submitted to us. So please check that out. We had a good time doing it. We think we might do it again. Maybe not every month, but every few months we'll do it again. And we announced some, or at least previewed, potential new summer merch that we're very proud of, and we would love for you to check it out. So if you are a member, go check out that Members Only Live from Friday. Then stay tuned this week. Tomorrow, Monday, we have live at 5 p.m. Pacific, 8 p.m. Eastern. Our guest will be Gavin Fish to talk to us about all the updates in cases that he's following this last week and the coming week. And on Wednesday, we're going live again for our Wednesday Night Live at 5 p.m. Pacific, 8 p.m. Eastern. And our special guest will be James Quealy. We had him on a week or so ago. He is an LA Times investigative reporter because on Wednesday is the date that both David and Nick Reiner will be in court. And he's following both of those cases closely. So please check that out. He's very good. He follows this stuff closely. He's got insights. He's got sources. Would love for you guys to check that out on Wednesday. CrimeCon is coming up in Vegas, May 29th through 31st. Be there. And if you are still looking to buy a ticket, they are available. We'll get you 10% off if you enter the word courtroom, all in caps, all one word. While you're there, please wear your brand new co-branded Courtroom Confidential t-shirt, available to all members now on the membership tab. And another reason that we're hoping that you will join us is that I have just been invited to be a speaker on one of their panels alongside Paul Morrow, Dono Rotuno, and Mike Ruiz, all from the weekly rap sheet. We're going to be breaking down the latest status on the Nancy Guthrie case. So we're hoping to get a lot of people to show up because we know it's a case that a lot of you are interested in. Paul was in Tucson for a couple of weeks. I was in Tucson for a couple of weeks. Mike Ruiz was there for a couple of months and was on the cutting edge of all the advancements in the case. So it's worth it alone to show up to hear Mike talk about this case. We would love to have you there. Lori Feeney, thank you so much for the support. Says Josh says we're the smartest community, but we're also the most fun. Yes, that's true. And those can both happen at the same time. Thank you, Lori Feeney. I want to give a special thank you to Dries 10 Jr. for becoming a new YouTube member, to Terry Payne Cardoza for becoming a YouTube member, to Lee in Tennessee, happy birthday, says come to the Sarges live after this with me and leave juice boxes. Yes, go do that. Everybody encourage that. And a special shout out and thank you to Professor Joe Potuto for answering our phone a friend question today. She is at Prof Joe. What is it? Prof Joe. I don't want to get this wrong. Prof Joe Explains. There's the link. If you go and subscribe over there, send her some juice boxes as well. But before we do anything else, we have to thank the greatest mod squad on the YouTubes to hold on. To Afton, Sonia, Kathy, therapists you know, and Best Nancy, thank you for all that you do. You guys are fantastic. We appreciate you. Couldn't do this without you. To Kaylin, I'm running out of words, Kaylin. You're the best. I appreciate you so much. And thank you for being our official Gen Z representative. Oops. I just messed up my whole screen here. Our official Gen Z representative. Thank you so much, Kaylin. And to Tiffany, you are, as always, the best thing that ever happened to me. Thank you, everybody. We will see you all here tomorrow night for our Monday night special, 5 p.m. Pacific, 8 p.m. Eastern. See you all there. Take care, everybody. Bye-bye.